Did you and your boyfriend go away together with your son on vacation?
No, ma'am.
The boyfriend didn't go?
He was not allowed.
But you went?
I sure did.
And you took your son with you?
Yes, ma'am.
That was after a hearing. Was there ultimately a hearing on that protective order with regard to the boyfriend?
Yes, ma'am.
And what happened with that case?
It got dropped.
When you say it got dropped, or did it get dropped, or did it get dismissed?
It got dismissed. Ralph didn't have any evidence.
Well, that's your conclusion. Did you have a trial?
I did not go. I was on vacation at the time.
You mean to the hearing? Did the boyfriend go?
Yes, ma'am.
Stand up.
Thank you.
Last name, sir?
Mr. Gould, or Gould.
Mr. Gould, you went to the trial.
Yes.
For the protective order.
Yes.
And was the protective order granted?
No, the protection order was dropped.
When you say dropped, it was withdrawn.
Withdrawn.
Okay, that's a different story. Do you understand, Miss Aldrich? That doesn't say didn't have any evidence. That means that Mr. Case had accomplished his mission, which was to prevent the boyfriend going on vacation with you and your son. Mm-hmm. So, mission accomplished. I don't have to proceed with this anymore. Now you can sit down.
Thank you.
I'd like to see the police report.
Police report, divine motion, and incident report. Emails, attorney fees.
Stop
and
talking to yourself, please.
Sorry,
Only old
sorry,
people
Your
talk
Honor.
to themselves. Okay, so let's get to first, Miss Aldrich, with regard to your counterclaim. Based upon this police report alone, it's dismissed. Your counterclaim for the plaintiff filing frivolous actions against you. I must assume that prior to this incident, which occurred on June 4th, 2016, that you had been enjoying visitation with your son on some weekends, correct?
Correct.
How long had you been enjoying visitation with your son? A month, 2 months, 3 months, 6 months, a year?
Years.
Years. And this was the first police report that was filed.
Yes, magistrate.
Okay. And the 4th was the actual date that Mr. Chase picked your son up from visitation.
Yes.
At your house. The officer's narrative, and I'm not quoting him, I'm quoting what the officer said that your son said to him. Your son said to the officer that the boyfriend hit him, which resulted in the bruises on his legs, shins, and back. That's what the boy told the officer. The officer documented that with photographs because the officer said, I saw the bruises, I documented them with photographs. So the plaintiff had every reason to file for a protective order against Mr. Gould based on this. As a matter of fact, he could have been charged with a neglect if he did not do so, knowing that Mr. Gould was again going to be alone in his company without his father present when you were on vacation. Now, you don't know, I don't know, certainly, and I'm not going to get that information here today as to whether or not the plaintiff coached your son to say that. However, based upon your statement to me that you have been having weekend visitation for years without incident, I have to assume that there wasn't an ongoing pattern of trying to disrupt your visitation with your son, but this was an incident that caused his custodial parent some alarm, coming back with bruises. Your excuse to the police officer who spoke to you was, we just took the training wheels off his bike and he fell. That was your reason. So he had every reason to do what he did. So your application for counsel fees is denied.